I know.
Welcome back to Beyond Motion. I'm Zach, here as always with my co-host Lindsay.
Hello.
Today we are taking a different kind of deep dive and exploring how biomechanics, the type of data that we help create, shows up in litigation settings. So it should be
Cool.
a fun topic to explore. So we'll be looking at slip and fall cases to product liability cases, even some shaken baby cases, and just see how biomechanics has made its way into the courtroom in all different kinds of ways.
I'm pretty excited about that. As a true crime podcast lover, I think this will be pretty fun to dive into the biomechanics of it all and see how, that kind of objective data about movement can inform some of these cases. And for us as product developers, it's really interesting because these aren't the settings we're usually thinking
Mhm.
about when we design tools for movement analysis, but definitely a way it could be used. So, I guess today you're going to be walking us through a couple of real life cases,
Yeah.
and we'll just discuss with questions and what this means for companies building the tech to analyze this moving forward.
Yeah, and hopefully give our listeners a little bit of education too about how this data, these tools are being deployed in these settings, and also look at what the limits are of biomechanics. What it can and can't say in a courtroom, which I think is a very important factor. So let's get started.
Cool. Let's do it.
So our first example comes from the case Doherty v. FDIC. So the situation is that the plaintiff tripped on a section of uneven sidewalk. It was only about 3/4 of an inch difference in elevation. And the defense argued that this was trivial and that the injuries couldn't clearly be linked to the site. Uh, Sounds like a good defense attorney, right?
Right.
No way, it was our fault.
Yeah. I mean, that's always the first thing you hear, right? It's
Yeah.
like, yeah, no, just try to get it thrown out.
But the plaintiff, in their infinite wisdom, brought in a biomechanics expert. And so this expert came in, they measured the surface, they analyzed typical foot clearance during walking, and they compared that to the reported injuries. And lo and behold, the analysis showed that the surface defect likely caused the trip and that the mechanics of the fall matched the injuries reported.
Hmm.
And the court admitted the testimony and helped establish the liability to the FDIC, who is responsible for maintaining that walkway as part of the building. I think I looked this case up in a little bit more detail too, and I think it was a Deutsche Bank. And so I guess that's interesting how the FDIC is responsible for the grounds of a particular bank. But
Yeah, that's an interesting aside. I
I,
wouldn't have guessed that.
no, I guess technically it is their, FDIC is the insurers for banks, so maybe there's something related there. But
Sure.
in any case, so this is a core example of how biomechanics are being used to analyze the plausibility of an injury mechanism. In this case, a trip due to a surface hazard.
Okay, so they weren't necessarily trying to say, here's the exact moment the injury occurred, but more like, is this scenario mechanically plausible, right?
Yeah, exactly. And that's really the core value that biomechanical experts bring to these types of cases.
Yeah, that's funny. Unless they had video recording how he fell, I imagine the biomechanical expert just kind of set up a situation where they could reproduce that uneven surface and just analyze a couple of different ways someone could have fallen. It sounds like kind of a funny scenario when you think about it, but I mean, very useful for this situation.
Yeah, definitely. And I wonder if it was a combination too of like you said, did they reset up a situation or did they go and visit the site?
Yeah,
Had the sidewalk already been corrected at that point, maybe
right.
to kind of cover up the situation a little bit? Clearly not, because they were able to do some measurements, but Yeah, and then you got to wonder like how deep did they get into it? Did how many subjects did they have come through? You know,
Right.
was it all modeling based? Like there's so many avenues here, but it's really interesting to see that you know, this evidence is being brought into the court cases and being heard as like a, you know, a testimony from an expert witness.
Yeah, for sure. Has there been any pushback on these kind of methods? Do the courts ever reject that kind of analysis as too speculative? I mean, we're obviously speculating
Yeah.
about how did they do that?
Yeah, definitely. And that's where I think the, you know, the rigor or the methods, or the rigor of the methods and the measurements, you know, have to be like really heavily documented.
Yeah.
And one thing that I noticed too about this case when I was looking into it was that it actually, the testimony was initially rejected.
Hmm.
Basically, the defense put up a statement that the expert was, you know, claiming that the injury happened because of this defect, and
Mm.
so that's a line usually that the courts will draw because the in this case the expert, they were not a medical doctor,
Right.
so they didn't have the expertise to then claim why an injury happened. They could just say from the standpoint of biomechanics that an injury could happen if these things, you know, all of this data lined up. So
Sure.
that's an area that if these experts stray into more of the medical diagnosis side of things, then the courts will exclude those testimonies. And I think that's a
Interesting.
really fine line that gets crossed often, and probably a lot of times, you know, these defense attorneys or teams are just waiting for them to cross that line so that they can just, you know, create a motion to get that thrown out of the case.
Yeah, I'm sure. I do think most people, like even judges and lawyers on the case, even really understand how biomechanics applies in cases like this.
I don't, that's a good question. I mean, probably not.
Yeah,
I think they hear the information that is being presented, and you know, much of it is like kind of a it's they take the approach of the scientific method, right, to
right.
analyze these things, and so they're putting the information out there, they're creating these reports, they're doing their best to be as factual as possible, and so it's completely data driven. So I think that, you know, the experts themselves are not necessarily concerned with whether or not the these people understand it necessarily, but
They're
that
just there to
they're
present the
exactly, yeah,
facts.
exactly. Just
Yeah.
like here's the facts, and then it's, you know, in most cases, if there's a juror or yeah, a jury involved, then you know, hopefully that comes across to them and they can make a decision based off of the information provided. But yeah, I think in terms of like actually understanding these things, you know, probably most people are, it's going above their head and they're just relying on this expert to deliver that information
Yeah.
in hopefully a way that's understandable,
Yeah.
at least.
Well, like in any way, an expert is brought onto
Yep.
a court case, right? I mean, not just biomechanics, but experts are brought on all the time to provide clarity on situations when, like, you need to have that specific context. But
Yeah.
I mean, with this case specifically, since the case was originally not thrown out, but, you know, like you said, it was rejected at first
Hmm.
because the lawyer or judge knew enough about, you know, what they were presenting to decide, you know, if there is a biomechanist presenting some kind of this is how the injury occurred, they
Hmm.
at least know enough to say, okay, that's not a valid extension of that hypothesis,
Yeah.
right?
Yeah, for sure. And that's what I think, like they're just kind of waiting to hear certain terms.
I guess
And then
so.
as soon as those terms are said or stated, then, you know, you jump on that
Yeah.
and kind of try and push that through to the judge to say like, hey, they're not qualified to make this statement, so we
Yeah.
can't trust anything that they're saying. So you know, that's the whole litigative process, right? Is just everybody trying to catch everyone else in
That's what it
saying
sounds
the
like.
wrong thing, and then it just drags those things out because at the end of the day, each side wants to win, right? So,
Yeah.
but yeah, and at the end of this, the testimony was accepted, and the case was seen, and the plaintiff received compensation for the things that they their medical bills and whatnot. So
Cool.
it was a successful expert testimony, I guess, even though it took a little bit of um, trial and error, let's say, for them to get this information to be accepted by the courts.
Yeah. Nice.
So we're going to move on to our second example here. And this one is looking at car accidents. And so biomechanics tends to come up a lot in car accident cases, especially in disputes over injury causation.
Okay.
Common examples include, low speed rear end collisions. The defense may bring a biomechanics expert in to argue that the forces involved were too low to cause serious injury.
Hmm.
And so, in multiple California cases, courts have allowed experts to present force and acceleration data, but have consistently blocked them from saying that this crash didn't cause this person's pain, which I think is kind of interesting. So, biomechanics experts can speak about the general forces and tissue tolerances, but that same theme, right? The specific
Yeah.
causation has to be uh, delivered by the medical experts. So
Sure.
that line can't be crossed in these cases.
Yeah.
Um, yeah, it's another situation where you're able to accept this expert testimony, but it can only provide so much information before it crosses a line, and it seems as though that regardless, these experts, unless they happen to also be medical doctors, I suppose,
Yeah, maybe.
then they
Yeah.
can't make any claims to like what actually causes the injury or doesn't cause the injury, I guess, in this situation, because it seems like a lot of times this is a defense scenario versus the
Okay.
other way around.
So they can say something like this level of acceleration probably wouldn't injure most people, but it
Mhm.
can't go as far to say this person isn't hurt or shouldn't be hurt because of that.
Yeah, exactly. So that's like the really important line for the experts to
Okay.
understand,
Yeah.
and they have to kind of track that as best as they can when they're presenting their information.
I mean, that makes sense. I mean, anytime you read a research study that talks about analyzing forces and how that relates to movement patterns, the like discussion rarely ever ends up saying like factually like this is what causes
Mhm.
this. It's kind of it's always a discussion, right? Like here's what we found based on research, and then it leads to more suggestions for more research a lot of the time.
Yeah, yeah,
So
for sure.
it seems like it's being presented in a very similar like research based fashion.
Yeah, it's probably pretty natural for these folks that are in coming from engineering or biomechanics,
Yeah.
academic institutions
Yeah.
who have PhDs in biomechanics or some form of engineering. They've written papers, so all of this stuff is very common to them, I think, and they feel
Yeah.
comfortable about it without crossing that line.
Well, I imagine so. Have there been any cases where experts have crossed that line and the testimony got thrown out because of that?
Yeah, definitely. One case that I found, the court excluded the biomechanics expert who tried to testify about the plaintiff's medical condition based purely on motion and force data. So they tried to just say that this plaintiff had this condition because of the motion and forces that
Okay.
were exerted, and just very plainly stated that. And the courts were very clear, and they said that biomechanics and the analysis of biomechanics can't replace clinical judgment. So even
Hmm.
though the evidence is compelling, even though it's probably right, that position, that expertise of the person that's delivering it seems to really matter in the court of law, which again, it makes a lot of sense.
Yeah, it does. I just wonder how much bias creeps into those
Mm,
cases. Like if an expert presents a super technical biomechanical analysis, does the average juror trust it too much because they're the expert, or tune it out because they don't know and they're waiting for the medical expert to come on and give the actual like here's what happened. So yeah, I just imagine it's pretty hard to strike the right balance when presenting that type of data.
yeah, definitely. I mean, I've never participated in anything like this,
I know,
and
yeah.
so I'd be curious to know kind of how that's set up. How do they introduce the expert? Obviously, whoever's bringing them in for testimony is giving some sort of introduction
Right.
to them, and then on the other side, whoever, whether it's the plaintiff or the defense, whoever is having to combat that testimony, is then trying to spend their time appealing to the jury, saying why the information shouldn't be trusted or taken as pure fact or causation. So
Yeah.
I that's I think if I were in the place of the juror, um I don't I think I'd take the information, and it would probably have an influence because I'd like to think that I'm a pretty common sense, driven type of individual.
Yeah. Yeah.
Um, but at the same time, like I would want that support from, the medical expert too.
Yeah.
So, but yeah, that's a good question. I bet it's really hard to strike that balance,
Yeah.
for sure.
Maybe
Eh,
one day if you get called for jury duty and
Yeah,
actually are on a case similar to this, you'll know how
yeah.
you'll react in
I
that
wonder if they would like
situation.
reject me though. Like, they do the backgrounds and
Yeah, they're
like, what do
just
you
like,
do?
"Oh,
And I'm
you
like, oh,
work
I
in
work. Yeah, exactly.
biomechanics?
Like,
Get out
sorry.
of
Yeah, I
here. We
can't
don't
do
want
this.
you."
Um,
Yeah, maybe.
Well, and the other thing too is like I imagine that these experts, as they're being brought in, whether they work for a company that provides these services specifically,
Yeah.
or as just an individual consultant or something like that. I mean, obviously they're getting compensated for doing the analysis, providing the report,
Mhm.
appearing in court, doing their testimony, and so I wonder how that's also constructed, like is
Right.
their contract related to the success of the court case, or is it just like pure, hey, do the analysis, like whatever you find, and we'll pay you, kind of a
Yeah.
thing.
Yeah, I
um
wonder.
it seems like that would be the least unbiased approach if it was,
Sure.
kept to that level, but
Yeah.
you never know. Again, at the end of the day, I think both sides want to try to win, so they're going to do whatever they can in a lot of ways within legal bounds. But
Yeah, it's like, okay, who hired the biomechanist?
yeah, yeah,
And
exactly.
what does that contract look like?
Yeah,
Yeah, yeah, kind of an aside, but that would just be interesting to know more about that process.
yeah. So, moving on. Our next story. This comes from a court case, Trice v. Doral Juvenile Group. And this is a product liability case looking
Okay.
at a booster seat. So the story is that a toddler was injured in a crash while
Hmm.
using a booster seat. And the parents argued that the seat's design allowed for too much forward movement, contributing to the spinal injuries that
Hmm.
the child sustained. A biomechanics expert reconstructed the crash with motion modeling and crash test data, and showing that the restraint system didn't adequately protect against the foreseeable injury mechanisms.
Hmm.
And so the court actually admitted this analysis, and it played a really significant role in the jury finding the product defective.
Wow. Okay. So here, biomechanics help not just with the causation of the injury, but evaluating the adequacy of this product's design.
Yeah, exactly. It provided that framework to understand whether the product performed as it reasonably should have.
How precise do these models have to be in court? Are we talking like full lab grade simulations?
Good question. From what I can tell, the courts don't require perfection, but they expect reasonable scientific rigor and transparency about the assumption. So I think that kind of goes back to our question from even the previous story about like,
Totally.
what do they just as a third kind of unbiased third party, what you find is what you find and
Right.
present it as is. Yeah.
Yeah, and obviously the opposing counsel often challenges those assumptions
Yeah,
and
100%. I
yeah.
mean, that's why it's so crucial for the biomechanical analysis to be well supported.
Yeah. That's interesting. So I assume then that company producing that specific type of like car seat no longer produces that car seat, huh? Um,
Yeah, I would
or maybe
imagine.
did an overhaul on the product design.
Yeah, one of the two. But that the seat itself probably doesn't exist on the marketplace anymore. At least not that you can purchase, right?
Yeah.
Um, yeah, it's pretty interesting. I think the part about this that stood out to me was that it was model based. So
Yeah.
there was no reconstruction of the site physically, but they used it, basically computer reconstruction.
hmm Yeah,
Uh,
so it took place in this virtual environment then.
right.
Do you think the growth of digital modeling tools is going to make this kind of analysis more commonplace in courtrooms? Are you ready for that?
um, yeah, definitely. I mean, I think just some of the exposure that we've had right in the industry and seeing how these digital modeling tools are being used in manufacturing processes and even I think on the other side of it like in more of the entertainment how
hmm
realistic that digital modeling can actually be.
Yeah.
um it makes sense that this would be available to use in this type of testimony. As far as, you know, is it going to be more common? I don't know. I mean, to be honest with you, I don't know the sort of statistics on like how often these types of court cases are brought up and, how often these experts are brought in to make these testimonies. I mean, it's got to be
Yeah.
enough to warrant, these several companies existing around the nation and probably globally
Yeah.
that employ, biomechanics experts to do this exact thing. But um, I I think that as these tools, as the computer software and the modeling software gets better and better, I mean, hopefully what it does is just provide better precision or maybe a little bit easier access to this type of information. Whereas I can imagine like in years past, like creating that digital model took weeks,
For sure.
and so what does that do for the court case
Yeah.
itself? Does it prolong it? Does that, create an issue to where this person who sustained this injury is not able to get, the compensation that they're owed for some time. And so they're having to stack up all these, bills out of pocket. And what does that do to their livelihood? And
Yeah.
so maybe that's the benefit that is gained as these tools become better.
Yeah, I imagine so it's obviously a lot easier. Well, I not obviously, but I suspect it's a lot easier to create a digital model because there's less cost involved with the physical setup
Yeah.
and things like that. But you're not only having to prove via the digital model that some adverse event happened, but you also almost have to prove the validity of the digital model. You know
Right.
what I mean?
Yeah.
Like you have to prove, okay, this digital model is this level of precision and accuracy because of this test and this test and this test. So, and maybe those are specifications that companies that do these digital models provide,
Sure.
which makes it easier, but it's just another layer of, going into the details like, okay, the digital model said this, but how do we prove that the digital model is doing
Yeah. How do
what
we
it says
trust
it's
that? Yeah.
doing? Yeah.
Yeah, definitely. That's an interesting perspective for sure. And I think just another call to action in terms of requiring that level of support for
Yeah.
these testimonies to be admitted in court. So it's interesting that they're already there. I mean,
Yeah, for
and
sure. That it's been used in court cases.
exactly.
Obviously, they proved that it was valid enough to be deemed acceptable for that
Yeah.
case. Yeah.
Yeah. So I guess we'll see. I think, our exposure to a lot of these digital human modeling tools and things has been more so in like the manufacturing side of things, but I wonder
Yeah.
if we'll get more exposure or have some interactions with some of these companies that are doing this for legal purposes
Yeah, I think that would
or
be really
expert witness
cool.
purposes. Yeah.
Yeah, because your interaction and my interaction with most of these companies doing this digital modeling is they reach out to us because they want a product that can analyze this thing.
Hmm.
And they tell us a little bit about what their intention is, and we advise them on whether the product is appropriate for that type of thing. But
Yeah.
then they get the product and then they do what they do with it. And, we kind of don't know exactly how it works from there, right?
Yeah.
So,
Yeah, I think equally important for us, right, to be very matter of fact with what our products can and can't do too.
for sure.
If that ends up being the use case, I mean, obviously that's something that we like to share with our customers, regardless of what they're doing. But if there's any knowledge that it's going to be used in these expert witness scenarios, it's like,
Yeah,
okay, let's be really clear here,
totally.
what's gonna be delivered by this system and what you can expect.
Yeah,
And
absolutely.
yeah, because we don't want that coming back to us, right?
No. And to me, it's just really interesting to hear about how individuals are using this technology like that because like we established earlier, this isn't necessarily the main use scenario we come up with as we
Hmm.
develop these tools. So
Yeah.
it's just always really exciting to hear about all of the vast variety of applications available for motion capture, EMG, force technology,
Right.
things like that.
Biomechanics, it's all around
It's
us.
all around us.
All right. So next story. So one of the more controversial use cases of biomechanics in court involves shaken baby syndrome cases.
Hmm.
So historically, courts relied heavily on biomechanical model that said that certain brain injuries were clear signs of abusive shaking. But in recent years, newer biomechanical studies have challenged whether typical adult shaking can actually generate forces high enough to cause those injuries without impact. And so this presented in two cases. There was a New Jersey and a Wisconsin case. And this evolving research contributed to overturned convictions.
Hmm.
Biomechanics didn't say that the abuse didn't happen, but it challenged a key assumption about the injury mechanisms.
Okay, so here biomechanics was used to challenge older model assumptions, but not necessarily provide an alternative cause.
Yeah, that's how I'm interpreting it, right? Is that it helped the court understand that the mechanism
Hmm,
wasn't as straightforward as it was once believed. Uh,
interesting.
where, just by shaking this child that you could cause certain brain injury.
Yeah.
So,
Yeah, it must be difficult to challenge older assumptions like that previously were just taken as
mhm.
facts, right? How do courts evaluate newer biomechanical studies in these cases? Is there a higher bar, higher standard?
Yeah, I think it's, requires science that's peer reviewed, well substantiated, and presented carefully. Again, not crossing that line going into medical diagnoses.
Right. Good. Yeah, this one is really interesting. Like, how does the legal system handle cases where biomechanical science is clearly evolving? Should convictions based on older science be automatically reviewed, reopened?
Yeah, that's a heavy one. I don't think that that's legally possible.
Yeah.
But
Or like practically possible in
yeah,
terms of
yeah,
like the amount of workforce it would take to reopen all these new
yeah.
convictions. But
But no, for sure. I mean, I think that as new evidence becomes available, then there's an influence on these, cases that occur in time. But I think that's something, within the legal process that's really hard in general, is to always challenge precedent that has been set by previous cases. And in a lot of ways, like in the courtroom, most of the how they're sort of establishing, either the plaintiff's position or the defense's position, is by using previous cases that dealt with similar situations and how those
right,
were ruled. And so, in cases like this, where the science is evolving, there's new information, they're having to spend a lot of time challenging those previous assumptions and
right,
establishing a new precedent with these cases.
right.
That obviously is going to then influence the decisions that are made on those ones, and then any future cases.
Yeah, and once that new precedent is established, I guess future cases, can no longer rely on the old precedent and
Yeah,
may have to continue doing a little bit more effort to continually maybe prove the new precedent as more information becomes available because there's not as much old case data to go off of. Like, okay, these 10 cases
yeah.
already prove this.
Yeah, this is a total sidebar here, but who is analyzing shaking babies?
Yeah, I don't know.
Where does that come up? But maybe that's exactly, again, like a law firm, right, is hiring some third party, and they're like, hey, this is the case we've got, like, do what you can, kind of a
Right.
thing.
Well, I have
Um,
seen like I this was on a TV show. I don't even remember which TV show, so I can't shout it out or anything, but it was some kind of medical show maybe where they were describing how much you had to shake a baby and they literally had this model of a baby with like the brain rattling around in it and like the area of the brain lit up in this like clear globe of a skull on this
Interesting.
like baby doll if you shook it hard enough. So I assume it had like accelerometers in it. And it was
Yeah,
just going to show like, okay, this area of the brain and the back or the front is lighting up. So that's indicating what parts of, speech or movement
sure.
or,
Okay.
would be impaired based on that level of shaking
Yeah.
and movement of shaking. So I think those models exist as like practical tools that yeah, I don't know whether they're used to educate parents or
Right.
like doctors about that level of shaking, but I thought it was an interesting example.
Yeah. No, that is interesting. I wonder if they'll have to update that little device based
I
off of
know.
this new information.
Yeah, for sure.
Yeah, interesting story for sure. And like you said, one that really makes you think how the legal system is supposed to use this information when there's all these possibilities for change, right?
Yeah.
So I guess that kind of somewhat segues into the next section here. And so in this one, this was a Kentucky case, and basically what it articulated is what's now called the Goldilocks zone for biomechanical testimonies. And this sort of plays on some of the questions that we've had about, like, how detailed does this have to be? What type of information do you have to provide? How
Yeah.
substantiated is it? And so essentially what this ended up defining is that biomechanical experts should not be too vague, not too broad, but they also have to avoid overreaching into the medical causation, which we've established. And so
Right.
the courts want them to stay in a very well-defined role, explaining forces, motion, and the plausibility of injury based off of that information, but not telling juries what medical outcomes did or didn't happen. So just pure information delivery,
Yeah.
no 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 statements of like this did or didn't happen because of the results or the information that we've gathered.
Yeah, and that's kind of the same line that we walk as product developers, and as we explain how this type of technology and our technology in particular works. Like we provide the tools to make sure and basically say that these tools are precise, but we don't overstate that, using these tools will cure some kind of
Yeah.
disability or be able to tell you whether some injury mechanism will happen or is happening.
Yeah, for sure. You hit the nail on the head with that one. It's about providing useful, transparent information, but without making any claims that, the data can't actually support.
Do courts require that these experts explicitly state those limits in their testimony?
Yes,
Okay.
and I think that was what was established in this case is that they basically defined what the best practices were and requiring those experts to clearly say what they can and can't speak to. So I think even as we were talking about that earlier, when this expert is brought in to testify, they kind of have to set the stage and let the jury know, here's what I'm able to tell you. Here's what I definitely can't tell you. So take what I'm giving you within that context.
Interesting. So we're talking a lot about this Goldilocks zone for biomechanical testimony, but what do you think about like product developers like us in
Mm.
terms of that Goldilocks zone? Do you think we should also define a sort of Goldilocks zone for how customers use data, and how proactive should we be on making sure those bounds are stated?
Yeah, that's great questions. I think that's very important for us, especially noting that we have certified medical devices, right? So
Yeah,
there's certain classifications for those medical devices, and we have to abide by the rules given to us from those governing bodies.
for sure.
And if we cross those lines, then that classification changes, and now we have to provide more evidence, more clinical evidence that the tool itself is doing, this thing,
Hmm.
clinically speaking. And so, uh, I think that that's definitely important for us to define and something that we do, right? I mean, like we
Oh
kind of
yeah,
state it through the technical specifications and, obviously in conversations with customers, letting them know what information can actually be gathered and what can't be gathered. I
hmm,
think in terms of like using that data, that's where I think we sort of allow them to have their own discretion on that. You know what I mean? Like
yeah,
it's not
definitely.
we're not saying, okay, you can unless it's outside of the bounds technically, right?
Right. There's a
Like
difference between stating the technology is capable of measuring this, and the technology can definitely answer your research question,
right,
you
right.
know?
I think like an example, two examples. So first is like our original IMU sensor system, right? The Research Pro system.
Yeah.
Uh technically it was not capable of measuring rotational velocities above 2000 degrees per second.
Hmm.
So that sort of set the limit as far as like what the use cases were. However, and you probably remember this, but we had several customers that wanted to go past that, whether it be looking at baseball pitching or something that required, these high velocities to be
Yeah.
captured. And so despite our sort of information giving them saying like, hey, it's not going to be able to do that, a lot of times they would still go ahead and do it.
Yeah.
And they would maybe look at all of the information up till the point of, eclipsing that technical bound.
Yeah. But it just goes to show how important education is on like why certain technical specifications matter,
Mm-hmm.
because we clearly provide those technical specifications, limits at 2000 degrees per second. But if that customer never in pre-sales conversations brought up that they were thinking of using the product for baseball pitching, we might never have stated that it can't do that,
Yeah.
you know? So it's one of those things where that information is available in many ways in as like sales and marketing tools and technical specifications, but it still can be misunderstood by non-technical individuals.
Yeah. Yeah, and I think like related to sort of this topic, um, and our role as like the manufacturer of these instruments is again understanding what that use case is and making sure that we communicate clearly like whether or not it's capable of measuring that thing or not. So like for
Yeah.
instance, the car accident stuff. It's
Hmm.
like what type of impacts are you looking to measure?
Yeah.
Um, what does the science say that those impacts deliver in terms of acceleration? Is
Hmm.
that within the measurement ranges of the equipment? And so you kind of have to go through that decision tree in order to
Hmm.
decide whether or not the technology is going to be useful. um and again, I think our role in that is just being as straightforward as possible,
Got to present the
with that.
facts.
Yeah,
Yeah.
exactly.
Yeah. I'm always, I tend to err a little bit on the, maybe sounding a little negative sometimes because I want to make sure what the technology is not capable of measuring is
Yeah,
clearly communicated.
yeah,
Even though the technology is capable of measuring a bunch of stuff, there's still so much room for misunderstanding sometimes.
yeah, yeah. Gotta be clear for
Yeah.
sure. All right, so our final example involves a workplace injury litigation, specifically repetitive motion.
Okay.
And so there's a well documented case that involves the Pepperidge Farm biscuit plant. And workers on the high speed assembly lines developed carpal tunnel syndrome and other disorders. And so an ergonomist had already flagged these tasks as high risk.
Hmm.
And then biomechanical experts were brought in to analyze the repetitive motion, the grip forces, the cumulative loading, and had the task of correlating them with the injury risk data.
Yeah, sounds like no small task.
No, definitely not. And so the court ultimately ruled that these were recognized hazards and that the repetitive forces substantially contributed to the workers' injuries.
Hmm.
And so I think, in this case, this shows that biomechanics can also support more long-term causation analysis, not just acute events as we've gone through in our previous examples.
Sure. Yeah. So in this case, the cumulative load and task repetition mattered as much as the individual force events.
Yeah, for sure. And I think that, this obviously highlights the need for, biomechanical tools to support both those instantaneous and cumulative style analyses.
Yeah, going back to what the perspective is of the legal setting, right? Is there a debate about whether
Mhm.
cumulative risk modeling is too speculative?
Yeah, I think there can be, which is why, it's important that the cumulative models are backed by validated exposure guidelines and ergonomic standards.
Yeah.
There's a lot of tools that are out there for that have been developed by the governing bodies like NIOSH or their
Hmm.
colleagues, at different universities. And so I think that industry is no stranger to one, I think wanting to understand these cumulative risks uh, for the purpose of worker safety.
Yeah,
But on the other hand, I think it's also to protect the company as well, so that they don't enter into these situations where they have to one be down a worker and two provide that compensation for whatever injury has occurred.
for sure. I mean, it seems like these workplace injury cases rely a lot on that cumulative exposure, which is really hard to measure perfectly
Hmm.
because it takes so much time to prove that that cumulative exposure caused an incident or could have caused an incident.
Yeah.
Um, and, you know, the users of our technology utilize our systems for these scenarios often, or at least want to do research for those scenarios. But this actually highlights the scenario that these companies either have to pay an ergonomics expert or a biomechanist to help develop safe work practices and, efficient workplace design first, or they have to pay them to do it later when they get sued for it.
Yeah.
It's like there's no escaping the need to have this biomechanical or like ergonomic analysis done at these big manufacturing plants, it sounds like.
Yeah, I think that's it. It's important for these companies to take that into account. I you know the work isn't going to get done right unless these people are healthy and capable of doing it right. And I think we covered this in a previous episode too, but like it's not like there's people lining up outside these plants, right,
No.
to get jobs.
Yeah.
And so preserving that worker and their health is such a huge thing, especially these days. And so, yeah, whether that's new technology that helps kind of monitor these things and address them before they become issues, or being more proactive and going around and whether you're modeling the workplace environment or the tasks ahead of time, or once they are implemented, you're just making sure that you're doing these kind of spot checks from time to time. I think all of that is super important for maintaining that healthy workplace and avoiding these litigation scenarios, at least to some extent.
Yeah, for sure.
So today we've seen biomechanics used to assess the plausibility of falls, evaluate forces in car accidents, analyze product design in liability cases, challenge assumptions in shaken baby cases, define appropriate scope of expert testimony, and support long-term causation in workplace injury cases. So after going through all of these cases, what do you think surprised you the most about how biomechanics fits into the legal world? And has this changed how you think about where our tools might end up being used?
Yeah, I think the theme has been clear. I think as tool builders for us, we need to be precise about what our data
Mm.
can and can't show. So we have to be precise about what it can show and just as precise about it what it can't. And
Yeah.
then, I mean, as an effect, these biomechanical experts, their job is to communicate the same ideas, right? They can't go so far as to explain causation and hypothesize on whether the injury was in fact caused by an adverse biomechanical scenario.
Mhm. Yeah, absolutely. Yeah, that line between the useful biomechanical evidence and overreaching claims it's very real, and the courts will actively enforce it.
Yeah. So transparency, rigor, and humility about that tool's limits are key if you want your data to hold up under legal scrutiny, huh?
Well said. Well said. Yeah, and I think that's a good reminder for all of us, especially as these tools keep finding their way into new spaces like litigation and other parts.
Cool. Well, all right. That's it for this episode of Beyond Motion. If you've got questions or ideas for other intersections between biomechanics and the legal world, send them our way, and we'll see you next time.
Yeah, and don't forget to like and subscribe. And yeah, see you next time. Bye, everybody.